appellant number 3 has died now. You have to file a substitution. Sorry, ma'am. 8. Appellant number 8. Ajay Kumar Singh. And Ajay Kumar Singh.
When did he die?
As you date not aware, ma'am. So I've just been informed, ma'am. We will file a substitution along with the death certificate also.
Second appeal number 375 of 2016. The learned counsel for the appellant submits that the appellant number 8,
Ajay
the
Kumar.
respondent number 8, Ajay Kumar Singh.
Appellant.
Appellant.
Yes.
Appellant number 8, Ajay Kumar Singh, has expired during the pendency of this case. कितना टाइम चाहिए?
3 weeks, madam.
3 weeks.
Death certificate I have also got, and I have also told him to inquire about every other person's status, madam.
Post on 27th under the heading for others.
Item 35, second appeal term of 2017.
Where is the appellant? Where is the appellant? मिस्टर विजय कुमार शर्मा कहाँ है? फर्स्ट हाफ में थे। हाँ? कोई बात नहीं, अब डिसमिस पर डिफॉल्ट कर दें। इसको ना उठते समय तक नहीं आते हैं, TFT करते हैं।
Item 37, consultative item 37, second appeal 337 of 2018.
सिविल अपील का जजमेंट हम पढ़ लिए, लेकिन अपील ट्रायल कोर्ट का जजमेंट हम 3-4 पन्ना मिसिंग है।
मिसिंग है? किसका मिसिंग है? हमारा क्या आपका?
नोटिस गया था और मिसिंग अपीलेट कोर्ट का जजमेंट हम पढ़ लिए।
क्या करें हम? टाइम तो आपको मिला था पिछली बार कॉस्ट देने पर, है ना?
बहुत छोटा सा मैटर है।
बताइए क्या?
उसमें एक बार पेज 23 अपीलेट कोर्ट जजमेंट एक बार देखिए। प्लेंटिव अपीलान जो डिफेंडेंट नंबर 1 था, सूट फाइल हुआ था फॉर कैंसिलेशन ऑफ सेल डीड executed in favor of appellant by the defendant number 2 to 4. Page 23, paragraph 22. Without assigning any reason and without independent majority, when an appellate court affirmed the degree and judgment of trial. Page 20.
ऐसा है कि आप इसको जजमेंट जो भी है आप देख लीजिए। इस तरह से पार्ट में फिर आप बोलेंगे 3 पन्ना मेरे पास नहीं है, आप देख लीजिए। हम लोग इसको पास ओवर कर एडजर्न नहीं करेंगे, आप देख लीजिए, उसके बाद फिर बहस। की तरफ से कहाँ बुलाने? ठीक है, उसको बुलाएंगे।
Item 1 for final source.
आपने उसको फ्लैश कर दीजिए आइटम नंबर 44। आइटम नंबर करके
Item 1, second appeal 334 of 2017.
Playing some time, I'm not ready fully in this case. Very honestly, I must state at the outset.
पिछली बार तो कोई और आदमी नहीं।
हाँ, श्री अम्बस्टा सर आए थे।
तो हर बार के नए काउंसिल आके बोलेंगे कि हम तैयार नहीं।
I will argue that only 2 days accommodation may be given. I will argue.
फाइल खोलिए।
I have come with the file.
इम्पर्सोनेशन का केस है।
Now, my lord, kindly impersonation का केस है। जिस चीज पे रिक्वायरमेंट है सूट फाइल हुआ, if my lord केवल at the very outset only submission is if I need some help on certain point, only for that point matter may be adjourned. Otherwise, my lord may not.
बताइए किस पॉइंट पर आपको हेल्प चाहिए?
My lord, kindly see, my lord, so far as the second appeal has been admitted, admitted by terms of order dated order number 3, 31/8/2018. Now, my lord, kindly have a look to the plaint.
31st May 2018.
Yes, suit was admitted. Substantial question of law was framed.
Whether the fraud is required to be pleaded and proved by positive.
Yes, this was framed. Now, for Lord, therefore, my lord, just now I may be permitted to refer the case of the parties, because in this case, my lord will find that plaintiff filed a suit for declaration of his title and recovery of possession, and my lord will find, I will refer the plaint, that everywhere in the plaint, it is the case of the plaintiff that sale deed has been obtained by impersonation. by impersonation, by fraud. It has been stated in the plaint. Now, kindly see the relief portion. So, my lord, the plaintiff very specifically pleaded that his title, there is a cloud in his title on the basis of that illegal registered deed of sale. Because there was impersonation. And if my lord will have a look to the reliefs claimed in the plaint, what is the relief? So now, plaintiff was well aware that that registered deed of sale is illegal, but no relief was claimed. Now there is an argument that since the deed was by practicing fraud, fraud vitiates everything, it is void, it was not required.
Correctly, sir.
So now that is one limb of the argument. But my lord, kindly for that, why relief has not been sought and what is the ground, kindly see paragraph 14 of the plaint. 14 of the plaint. That the defendant, I am reading.
You stick to the question of law.
That's why, my lord, my submission that the defendant, this is a specific case of the pleading of the plaintiff, that this defendant came to know regarding title on the basis of deed in the year 2004
That's right.
and suit was filed in the year 2012. So, there is admission in pleading by the plaintiff. No relief in relation to deed has been sought. So now, at this juncture, my lord, my submission is that one additional substantial question of law may be required. Because limitation is just, my lord, limitation.
The question
Is
of
a-
limitation will come only if there was a need to declare the sale deed null and void. Right? Now there is an argument that if the deed was never executed
Yes,
by the concerned person at all,
correct, correct.
and if it is by impersonation,
Yes.
it is expressai fraud. So
Fraud.
no declaration
So,
is required.
yes, now Supreme Court says that if a deed is void, then plaintiff has to seek relief. Plaintiff has to seek relief under section 31 of the Specific Relief Act.
And without this,
So, for that purpose, my lord, because this is the last court, my lord, of suit is admitted now, beyond that we will not argue anywhere. So, for that purpose, two additional question of law, just I am proposing, if my lord, if I could satisfy, then my lord will accept it. Other, if I could not satisfy, my lord will not accept it. Copy. So, the additional substantial question of law is, in spite of knowledge of a deed, I say that yes, it was a case of impersonation. So they have the knowledge that they have, the defendant number one has title deed in the year 2004. So it was incumbent upon the plaintiff to seek relief in view of the decision of the Honorable Apex Court.
which decision is that?
Yes,
वो दीजिए
yes.
क्या आप substantial question of law request?
That's what, but otherwise I could not. Only just relevant paragraph I will show, my lord.
Specific relief act. ये जितने भी हमारे ट्रांसफर प्रॉपर्टी एक्ट है, स्पेसिफिक रिलीफ एक्ट है, सीपीसी है, ये सबका एक बंडल बनाइए। लिमिटेशन एक्ट है, एक बंडल में बांधिए सब। These are regular things that are required. Succession Act है, हिंदू लॉ है।
My lord, on the last page of the decision,
You just read section 31 first.
Any person against whom a written instrument is void or voidable and who has reasonable apprehension that such instrument, if left outstanding, may cause him serious injury, may sue to have it adjudged void or voidable, and the court may, in its discretion, so adjudge it and order it to be delivered up and cancelled.
This is the may, my lord, is the description of the court. On this point, my lord, one judgment is there of the 2020-24, my lord, which is not required, my lord, if the person is not parted in the execution of deed, my lord. This paragraph 23 is the relevant, my lord. Here, my lord, Article 56 is applicable, my lord, not 58 and 59 of the Limitation Act, my lord. So there is no question of the additional substantial question of law, my lord. And in these judgments, my lord, the very much replied to the substantial question of law, which has already been framed, my lord, by the Honorable Court, my lord. See the case with the postponations, my lord, and is from the evidence it proved, my lord, the petitioner was not present at the time of the execution of the said deed. And as per the report of the handwritten
Is
expert
void
also-
and void ab initio are one and the same?
Yes, same. Now this will help me, my lord. This case decision will help, and my lord, perhaps my lord has noticed also it, my lord, this paragraph, and before reading to that, my lord, kindly see this paragraph. My learned friend is relying. The last one. More particularly, when the person is not party to such an instrument.
Yes,
He's
Yes.
not a party.
not the
No.
party. This is the case of the impersonation and by the proof,
there-
by
there-
of evidence also, my lord.
when suit is filed. Now this is the stage of second appeal. Now section 31 will have to be seen at the stage of trial. Now why it is necessary? Now a person is saying in a deed of registered deed document, name of a person is signature of a person is given. This is the case of the defendant number 1. Now plaintiff says this is my not I am not there, but my signature is there. Now person, same name of persons is required.
His signature is not
Yes,
disputed.
that-
No.
No, disputed.
Signature is
Signature
disputed.
has, there is a
Disputed and
complete
proved, my lord, by handwritten
mismatch of
experts, not the
signature.
same person.
Hey, my lord, that's why there that's why at the very outset I stated that fraud vitiates everything. Now, but the question is, if it was obtained by a fraud, what stopped them from seeking any relief? Because of the fact that their suit was bound to fail. Their suit was bound to
They
fail.
need not seek
Now,
a
only
declaration.
in the court, only that an opinion has given a report, the entire case cannot be adjudicated. That's why, my lord, my first submission, my lord, may
See,
reject
you
it.
have framed an issue, right? That there is no pleading, which is not correct.
This is
There
not
is the
correct.
pleading, my lord, in paragraph 10, my
This
lord.
is not
This
So
is the pleading,
you
my
have,
lord.
at
In
your
paragraph
instance,
10.
this issue was framed.
that. But now,
It is specific pleading in paragraph 10, my lord.
pleading pleading and proved by cogent evidence.
That is
That is the second part.
That is also the
That is
proof,
the
Madam,
second
by
part.
way of the PW8, Madam, who is the handwriting expert.
Yes,
Madam.
I will come
And
to
specifically
PW8.
depose, Madam, the thumb impressions of this
I will
plaintiff and
come.
the-
I will come
the
to
said
that.
deed.
I am
Not
not
of
saying
the
that.
same person.
I will not come. I will certainly have on that. But the very first question. That's why I stated that I need some time. Why? Because
You need time for this.
yes, that's why. Because to argue and to get it decided, it is very easy. But sometimes I feel, in any case, I never, my lord, I always appear before my lord, I always argue, and even most of the time I also concede. Now, this is the last court, before a party can plead everything. Now, if section 31, if this is the law, that even a party, even a document wherein the name of a person is given, and he knows in the year 2004, now, there is pleading. Now, in that case, whether a relief was mandatory or not, nothing will happen, my lord, within a 4 or 5 days, and thereafter it may be decided. That's why I, at the very outset, to save my lord's precious time, I just referring these laws. If there will be not a single decision, I will concede, no, my lord, there is no a single decision. ये जो केस लॉ दिखा रहे हैं, जो एकदम लेटेस्ट है, इसमें भी देखने की जरूरत है कि इसमें 63 के सेंडी को जो चैलेंज करने की बात हो रही थी, उसमें कोई भी पार्टी का नाम नहीं था. अगर इसके फैक्ट्स में होता कि मिस्टर ए का भी नाम था और फिर भी मिस्टर ए इसलिए नहीं चूज किए चैलेंज करना क्योंकि वो इम्पर्सोनेशन का केस था, माय लॉर्ड, राइट नाउ आई विल कंसीड, राइट नाउ आई विल कंसीड, माय लॉर्ड.
This case of the Article 58 and 59 is not applicable.
तब तो
So
फिर अगर
therefore,
इनका
there is no
बात
question
अगर
of-
कहेंगे
Yes,
तो
this is
50
the case
हाँ,
of the 56.
इसीलिए तो कर रहे हैं कि खाली
This is the case of
तो
56.
हाँ, तो इसको लिमिटेशन पे पॉइंट फ्रेम कर लेने दीजिए. 31 और 58 59 का वायलेशन है कि
And it has become on the knowledge of this plaintiff.
हाँ,
Madam,
2
in the
दिन का टाइम
2011
दिया जाए.
itself, Madam.
हाँ, 2 दिन का टाइम दिया जाए और उसके बाद इस पे हम लोग
अच्छा एक बात बताइए, इतना ही सी पॉइंट ऑफ लॉ फ्रेम कर देते हैं, whether the deed would be said to have been fraudulently executed by impersonation without having specifically challenged the same. उतना से हो जाएगा, उतना से पूरा ही काम हो जाएगा. आखिर भाई कंटेस्ट है, इम्पोर्टेंट पॉइंट है,
ठीक है.
उतना ही से हो जाए.
इसका तो आंसर इस जजमेंट में है ही.
ठीक है ना, जजमेंट प्लेस करिए.
इसका आंसर इस जजमेंट में है.
There could be, you see, there could be a situation where a third party is executing a deed with respect to my property and selling it to Mr. X. तो ठीक है, उस deed को हमको set aside कराने का कोई जरूरत नहीं है, because that is
Third
fraudulent.
party there, they executed and by name, by impersonation, by committing the impersonation of knowledge.
But in a case where a deed is said to be executed by Mr. X and Mr. X is claiming that I have not executed this deed.
And it proved, Madam.
And
by way of the
whether,
evidence, Madam.
and it is to be proved through evidence.
Yes, it has been
Whether
proved.
the suit was required to be filed for setting aside that sale deed or not. Is the point,
Yes,
isn't it?
therefore this judgment.
If it is proved that he has not executed it, then under such
not required to
circumstances
challenge.
he is not required
Not
to be
required to
challenged. This is what your case is.
Yes, Madam.
But he says that no, it has to be challenged. So let that be one of the issue. We will hear it. Records have already come. You also do your homework on this. But this additional issue we will frame. अगर उसको set aside कराने की ज़रूरत थी, right? Then under such circumstances the question of limitation etc. would come. So अगर उसको ज़रूरत ही नहीं थी set aside कराने की, there is no
There is
question
no
of any
question of the
limitation.
limitation, Madam.
तो limitation वाला point हम लोग को frame करने का कोई ज़रूरत ही
नहीं.
नहीं. ठीक है? During the course of arguments, the learned counsel for the appellant has submitted that an additional question of law arises for consideration in this case based on materials on record. He has submitted that the deed involved in this case the registered deed involved in this case, which has been held to be executed through impersonation, was never challenged before the learned trial court, and this was so primarily on account of the reason that, as per the plaint itself, the plaintiff came to know about the deed way back in 2004 and had filed a suit seeking declaration of right, title, interest and possession in the year 2000. He has submitted that if the deed was sought to be set at naught, then the relief would have been barred by limitation. The Learned Counsel has also referred to section 31 of the specific relief act. The Learned Counsel for the respondent, while opposing the prayer, has submitted that if the deed was, that there is concurrent findings that deed was executed through impersonation, the same is void ab initio, and accordingly the deed was not required to be challenged. However, considering the contest involved in this case and also the fact that the deed was not specifically challenged in the suit, this court is of the view that one more additional substantial question of law is required to be framed for consideration, : whether the sale deed executed through impersonation of the vendor was required to be specifically challenged in order to declare the same as nullity / void ab initio. ठीक है, हो गया? अब कब करेंगे ये बताइए?
Any date in the next week.
जजमेंट खोज लेंगे आप लोग कि हम ही को करना पड़ेगा?
नहीं नहीं
खोज लेंगे, मेरे अगेंस्ट में रहेगा वो भी आप फिल कर दे देंगे।
है
तो
जो
पहले भी कंसीड करके हम दिखा
जजमेंट हम ले
देते
आएंगे
हैं, दोनों तरफ से जजमेंट है, लेकिन यहाँ पर हम नहीं इतना आर्गूमेंट करते। अगर ये पार्टी डीड में नहीं होते तो मैटर मेरे अगेंस्ट में हो जाता।
ठीक, ट्यूसडे को रखें?
मैं
वेडनेसडे ट्यूसडे आता है
अच्छा हाँ 14 तारीख
14 तारीख को नहीं,
वेडनेसडे
Wednesday. Pose this case on Wednesday in the supplementary cause list. ठीक है, हो सकता है फर्स्ट हाफ में ही होगा क्योंकि कुछ
215 नहीं
मैटर्स
रखा
हैं,
जाएगा
कुछ मैटर
ये
रखे
hearing
हुए
का
सेकंड
matter
हाफ
नहीं
हियरिंग का मैटर है तो इसका क्या
नहीं,
मतलब?
कोई मतलब नहीं, रख दिया जाना होगा, टेकअप हम लोग करेंगे।
तो आज भी अटेंड नहीं करते
नहीं,
क्योंकि
नहीं,
एडिशनल
हम लोग
क्वेश्चन ऑफ
करेंगे।
लॉ तो कभी भी फ्रेम कर सकते हैं हम लोग, ऐसा नहीं करते क्योंकि उस दिन हम कुछ मैटर्स रखे हुए हैं सेकंड हाफ।
नहीं नहीं ठीक है, हम लोग रहेंगे कोर्ट में। डीपली हो गए।
गोराई जी को जब बुलाइएगा उनको रिसर्च करना। सर वो सीरियल नंबर 44 था, उसका हम ऑर्डर कर दिए।
कंक्लूड कर चुका है।
हाँ, हम इसीलिए आपको बुलाए
नहीं,
हैं
मुझे कोई दिक्कत
एंड आई डिसमिस दैट
No, I
हम
do not
ऑलरेडी
want-
डिक्टेशन दे चुके हैं
I do
चेयरमैन
not
में।
want to add
हाँ।
anything more.
ठीक, वो डिसमिस
Sorry, हम उसमें
ऑर्डर अपलोड हो जाएगा कल परसों तक।
Yes,
ठीक है, हम ऑलरेडी डिक्टेशन दे चुके हैं
कोई
इसीलिए
दिक्कत-
आपको बुलाया।
कोई दिक्कत
ठीक, हो गया नहीं? Dismissed।
सॉरी उस समय तुरंत नहीं आ सका
नहीं कोई ऐसा जरूरत नहीं, लेकिन आपको बिना पूछे सीरियल नंबर 44 ऐसे कॉल आउट करके नहीं कर सकते।
हम तो उस दिन बोल देते हो जो कंक्लूड के
वो ऐसे पोजीशन ऐसा हो गया केस का ना कि थोड़ा सा हो सकता है टेकअप ना भी हो। इसीलिए
Passport case Act 35, second appeal of 2017.
कहाँ आपने इस केस में सिविल अपील नंबर 10 ऑफ 2016 के ऑर्डर को चैलेंज किया है ना? द अपील हैज बीन डिसमिस्ड ऑन लिमिटेशन, तो मेरिट का तो कोई बात ही नहीं है, लिमिटेशन पे सेटिस्फाई करिए। क्या है इसमें? क्या ऐसा क्वेश्चन ऑफ लॉ अराइज करता है कि सेकंड अपील में हम उस लिमिटेशन में
Limitation may also belong to the second appeal, Lordship. This may Lordship be because of the defendant appellant has filed the petition miscellaneous appeal in wrong forum, Lordship.
कहाँ से कौन से फोरम में आप आए?
ये फाइल कर दिए Lordship एक्स पार्टी ऑर्डर को, उस ऑर्डर कोई कहीं तो हमारे नॉलेज में नहीं था, एक्स पार्टी ऑर्डर को मिसलेनियस केस में चैलेंज करने के लिए, and then thereafter the time has
कहाँ है वो सब? कहाँ
आया है
reference?
Lordship, page 14 में Lordship, क्या है Lordship? May I read the title?
बताइए।
A record put up for hearing of the condemnation petition filed by the appellant under section 5 of the limitation at both the parties and
ओरिजिनल डिग्री कब पास हुआ था? डेट्स बताइए। व्हाट इज द डेट ऑफ ओरिजिनल डिग्री? 1988
1988
है ना?
Lordship.
और मतलब 14/5/1992 को पार्टीशन सूट नंबर 15 ऑफ 1988 डिग्री हुआ। उसके बाद क्या हुआ? डेट बताइए।
It was title appeal filed your Lordship filed by the defendant on your Lordship.
टाइटल अपील फाइल ऑन
24th May 1992 your Lordship.
24/5/92
1992 your Lordship. Title
उसके
appeal
बाद-
number 28
हाँ,
of 1992.
28 ऑफ
1992
1990
on the same
ये
date,
रिमांड हुआ
Lordship.
और जजमेंट का डेट बताइए।
Judgment date of decree, judgment date of 14 May 2019.
14/5/1992।
Lordship. Najwari National Fund, कोई fund.
उसके बाद फ्रेश डिग्री कब हुआ?
And thereafter the French degree was prepared, your Lordship, on 29th September 2004.
29/9/2004
Lordship.
करेक्ट।
Lordship.
उसके बाद आपने क्या किया? मिसलिनियस एप्लीकेशन
Miscellaneous file.
कब फाइल किया?
Miscellaneous has been filed, your Lordship, on
बताइए ऑन बताइए।
Lordship. Miscellaneous case 1/2006 your Lordship, बीत पर
ठीक है।
Lordship. And it was dismissed on 27/7/2007 Lordship.
22/7
22/7 Lordship. And then thereafter Lordship, again the file the miscellaneous case your
ये
Lordship.
इसका क्या मतलब? मिसलिनियस केस का मिसलिनियस केस करते रहिए।
Lordship.
आपने जब पहला मिसलिनियस केस फाइल किया तभी भी आपका अपील टाइम बार्ड हो चुका था,
Lordship.
राइट?
Lordship.
So your first step against the decree was already barred by limitation. इसीलिए सेक्शन 14 का आपको कोई रिलीफ नहीं मिल सकता।
Lordship, because of the no knowledge of the
नो नॉलेज ये सब का कोई ग्राउंड है क्या?
deep
Knowledge. Litigant is supposed to have knowledge, or advocate is supposed to have more knowledge.
Lordship, due to negligence.
कुछ नहीं, कुछ ही है ही नहीं। इसमें क्या है? उसके बाद आपका 22/7/2007 को डिसमिस हो गया, फिर आपने दूसरा एक एमए फाइल कर दिया।
Lordship, उसी में
बताइए।
फाइल करते रह गए फिर पुनः
नहीं बताइए ना क्या एमए फाइल किया उसके बाद? क्या फाइल किया?
फिर डिसमिस फॉर डिफॉल्ट तो उसको रिस्टोर के लिए फाइल किया Lordship.
हाँ, तो दिस वाज डिसमिस फॉर डिफॉल्ट।
Lordship. Again,
जस्ट अ मोमेंट, ये डीएफडी हो गया था।
Lordship.
मिसलिनियस केस नंबर 1 ऑफ 2006 डीएफडी, करेक्ट?
Lordship.
इसका रेस्टोरेशन के लिए आपने कब फाइल किया? दैट वाज मिसलिनियस। उसके बाद आपने उसको मिसलिनियस
Miscellaneous
सिविल
case-
अपील नंबर 5 ऑफ 2007 में चैलेंज किया।
Lordship.
मिसलिनियस जस्ट
Miscellaneous
सिविल
appeal,
अपील नंबर
5 of 2007.
5 of 2007 को चैलेंज
Same was
किया,
dismissed on
which was dismissed when
21st January 2016.
नहीं
एक उसी में
नहीं, सिविल अपील was dismissed on 7/6/2010 for non prosecution,
Lordship. And again
right?
miscellaneous case
7/6/2010 for non, ये फिर DFD हो गया,
Lordship.
करेक्ट?
Lordship.
DFD का पूरा हिस्ट्री है आपके केस में। उसके बाद आपने फिर एक फाइल किया, क्या फाइल किया? फिर आपने मिसलिनियस केस 3 of 2010,
Miscellaneous 3 2010
नहीं 3 of 2010 आपने फाइल
Lordship.
किया। ये क्या चीज के लिए फाइल किया? ये जो ऑर्डर था उसको चैलेंज किया,
Lordship.
ठीक है? which was dismissed on 21/1/2016,
Lordship. 21/1/2016. Lordship.
2016, ठीक है? उसके बाद
And then thereafter, when the knowledge, when they come into the knowledge of the final degree has passed, Lordship,
और अपील आपने उसके बाद फाइल कर दिया
then after appeal has been filed.
27/2/2016।
27/2/2016.
Section 14 में there are 2 conditions
Lordship.
that you should be prosecuting your case diligently. जिसका केस इतना बड़ा DFD हो रहा है, diligence कहाँ है? Totally absent.
Lordship,
Correct?
Lordship.
पढ़िए Section 14 Limitation Act. नहीं,
Due to wrong forum, Lordship.
wrong forum नहीं है सिर्फ, diligently before wrong forum. Your initial step was barred by limitation. Then you did not follow your case diligently before other forums because your matter was dismissed for default time and again for non-prosecution. क्या कहानी चलते रहेगा क्या? पढ़िए सेक्शन 14, दीजिए, उनके पास एक्ट नहीं होगा, लेके नहीं आए होंगे, पढ़िए। घर पे नहीं पढ़े होंगे ना, यहाँ पे पढ़ लीजिए।
Exclusion of the time.
पढ़िए।
Exclusion of the time of the proceeding bona fide in court without duration. In computing the period of the limitation for any suit, the time during which the plaintiff has been prosecuting with due diligence another civil proceeding, whether in a court of the first instance or of a appeal or revision against the defendant, shall be excluded where the proceeding relates to the same matter in which and is prosecuted in a good faith in the court which from the defect of the resolution or the cause of
Due diligence and in good faith,
Lordship.
बस काफी है। चलिए
Lordship.
लिखिए, सेकेंड अपील
Lordship,
नंबर
kind
10
of
of 2017।
judgment, your Lordship.
हाँ लाइए जल्दी।
Section due to wrong to the plaintiff defendant is the illiterate person Lordship. No knowledge.
नो
about the
नॉलेज
law.
का तो कोई बात ही नहीं है ना।
law का knowledge इसके as per the advice of the council your Lordship. He has taken the plea your Lordship in the
सू कर दीजिए उनको, एडवोकेट।
and first appeal was not heard on the
कोई
merit your Lordship.
Need not be. We don't permit those persons who are not diligent with their cause of action. नहीं, लीजिए कौन सा जजमेंट है?
उसको Lordship के टाइम दे दिया
कोई टाइम हो गया ना, अपील के लिए टाइम।
नहीं Lordship का
सुन लिए काफी।
as per my satisfaction your Lordship.
क्या चीज? योर सेटिस्फैक्शन।
Lordship
यहाँ आपको सेटिस्फाई करने के लिए नहीं बैठे हैं।
Lordship को हम satisfied करेंगे Lordship.
कल के
वहाँ से
लिए
इसको लिमिटेशन का और पिटिशन देख लेते हैं Lordship, जो लिमिटेशन जो फाइल हुई की है सेक्शन 14 और 5 और 14 का Lordship, हम थोड़ा सा उसको देख लेते हैं Lordship. मेरे पास वो नहीं है कि मेरे एक टाइम दे दीजिए
नहीं,
Lordship.
टाइम नहीं देंगे ना, टाइम नहीं देंगे।
नेक्स्ट वीक में या Lordship
आपको पहले जो है ये कितना पेमेंट 2000 रुपए
Lordship,
पेमेंट करके टाइम हुआ था।
Lordship.
नेक्स्ट वीक में देंगे 20,000 रुपए पेमेंट देंगे नेक्स्ट वीक टाइम। 20,000 से एक पैसा कम नहीं, जमा कर दीजिए बाय फ्राइडे, वी विल हियर इट ऑन ट्यूसडे। कोर्ट का टाइम वेस्ट करते हैं, ट्रायल कोर्ट का टाइम वेस्ट करते हैं, एपेलेट कोर्ट का टाइम वेस्ट करते हैं, और यहाँ पर भी हम लोग का टाइम वेस्ट करते हैं। A litigant who is not diligent.
कल
ठीक,
देख
देखिए ऐसे नंबर 10 और 2017। The learned counsel for the appellant is present. He submits that the matter arises out of partition suit number 15 of 1988, which was decreed on 14/5/1992. A title appeal was filed by the defendant on 24/5/1992. A title appeal was filed by the defendant. ये 14/5 को तो नहीं डिक्री हुआ होगा, which was decreed in the year 1992. A title appeal was filed and the matter was remanded. White, judgment dated 14/5/1992. Upon fresh adjudication, the decree in the title suit was drawn on 29/9/2004. The decree was an ex parte decree. He submits that against the ex parte decree, the appellant filed miscellaneous case number 1 of 2006, which was dismissed for default. On 22/7/2007. The said order was challenged in miscellaneous civil appeal number 5 of 2007, which was again dismissed for non-prosecution on 7/6/2010. Thereafter, another miscellaneous case number 3 of 2010 was filed, challenging the dismissal order dated 7/6/2010, passed in miscellaneous civil appeal number 5 of 2007, which was ultimately dismissed on 21/1/2016. And thereafter, the appeal was filed before the appellate court on 27/2/2016 with a prayer for condonation of delay under Section 5 of the Limitation Act. The learned counsel has referred to Section 14 of the Limitation Act to submit that the appellant was pursuing his remedy before other forum, and therefore the period during which the appellant was pursuing his remedy ought to have been condoned by the first appellate court, and consequently a substantial question of law arises for consideration by this court. In the backdrop of the aforesaid series of litigation, / petitions filed by the appellant, which stood dismissed for non-prosecution time and again, this court is not at all satisfied that the provisions of Section 14 of the Limitation Act would come in the rescue of the appellant. The appeal was filed with a delay of 4,137 days. At this, the learned counsel for the appellant has submitted that one opportunity may be given to him and submits that the matter be posted for further hearing tomorrow. Post tomorrow. Absent मत रहिएगा, पास ओवर नॉट टुडे कुछ नहीं है. नहीं रहिएगा तो यही इसी ऑर्डर पर डिस्मिस करेंगे.
Item 40, second appeal 396 of 2018.
Yes, applicant. The respondent. Where is the applicant? You have filed a caveat. You are for the plaintiff or the defendant? आपने
सूरज द मुंडा है नेक्स्ट प्रक्रिया है इसमें एंगेज करना है लोग से सीनियर कॉन्सेप्ट सुधीर कुमार ये रिवर्सल जजमेंट कैसे करना है
सूट क्या चीज के लिए?
For declaration of right title interest and permanent injunction.
The suit was dismissed or decreed?
सूट को अलाउड
Suit was decreed.
डिग्री
No, suit was
Suit
dismissed.
was
Your
dismissed.
Lordship. Then we filed the appeal, and now they have come to this appeal.
And you are the plaintiff.
I'm the plaintiff.
What is the point of determination by the appellate court?
It's page number 7 of the judgment, Your Lordship. Is the plaintiff applicant entitled for declaration of his right title interest in possession over his suit land by virtue of two sale deeds executed in his favor by Srimati Giribala Devi? We are claiming the title on the land on the basis of these two sale deeds, Your Lordship. That is sale deeds dated 18 September 1974. The case of the defendant is that our predecessor in interest, Giribala Devi, had no right title interest on the suit
She
property.
never had the title.
Yes, Your Lordship. But our case is that the land was settled to her by way of hukumnama in the year 1942, and she was paying rent to the Raja of Jharia. She had got the hukumnama from, and after the vesting, she was paying to the state, Your Lordship. Her name was also recorded in the Hoka of Dhanbad, Your Lordship. And the defendant had never filed for cancellation of sale deeds, Your Lordship. They are claiming through the recorded tenant, Your Lordship. They are the successors of the recorded tenants, Your Lordship, in whose name the survey records of right was recorded, Your Lordship.
Where is the discussion in connection with the findings recorded by the learned trial court?
The point of determination was
This is the point of determination
Yes,
we have seen.
Your
Where is the
Lordship.
discussion of the findings recorded by the learned trial court? In a case of reversal, the appellate court is duty bound to refer to the reasons given by the learned trial court as to why the appellate court is not concurring with the findings of the learned trial court. The finding starts from para number 11.
Your Lordship, the lower court's findings were not discussed.
Certainly, it is required to be discussed. If not discussed, the matter has to be remanded. After framing this substantial question.
Your Lordship, para number 13, there's a
Just one line.
just that on the basis of above discussion, I find that the learned court has erred and decided titles
What do you
by dismissing.
What do you mean? What does that mean? The judgment has not been passed in terms of the provisions of Order 41 Rule 21. In the case of reversal, the reasons of the learned trial court is required to be discussed. It has to be found to be faulty. There is no discussion. Now there are two parallel findings based on the same materials. So, record आया है इसका? बताइए क्या बोलना है? क्वेश्चन ऑफ लॉ कहाँ फ्रेम किया? कौन से सीनियर को आपको बहस कराना है बताइए?
मिस्टर सुधीर कुमार सर।
हाँ,
मिस्टर सुधीर कुमार सर,
बुलाइए उनको।
वो अभी तो फाइल दिए भी नहीं।
अरे भाई वो बहुत तेज आदमी है, वो उनको ऐसे सुन के समझ आ जाएगा क्या हम बोल रहे हैं।
इसमें परेश लॉर्डशिप सूट लैंड बिलोंग टू ट्राइबल लैंड और कोई परमिशन वगैरह भी इसमें लिया नहीं है।
आप ना मेरा बात सुने ना समझे,
हम
समझ गए ना? बुलाइए उनको काम, बुलाइए इसको, झूठ मूठ का एडजर्नमेंट नहीं करेंगे। फीस आप उनको दे दीजिए। कल रखें, कब रखें बताइए? आपका फेवर का बात करते तो भी नहीं समझ में आता। बुला लीजिए ना, नहीं आएंगे क्या कोर्ट में? कहाँ सब्सटेंशियल क्वेश्चन ऑफ लॉ कहाँ फ्रेम किया है बताइए? बहुत रेगुलर फीचर है। The findings of the trial court are not being discussed by the appellate court. क्या ही चल रहा है झारखंड में? This is repeatedly it is coming. They reverse the finding without discussing the finding of the trial court. कहाँ है आपका substantial question of law बताइए? कब करेंगे बताइए? अभी आप लेके भी नहीं आएंगे, उसके अलावा कोई क्वेश्चन ऑफ लॉ फ्रेम कराएंगे तो क्या ही बोलेंगे? परसों ठीक है। The learned counsel for the parties are present. The impugned appellate court judgment is a judgment of reversal. The title suit was filed seeking declaration of right, title, interest and possession and was dismissed by the learned trial court after framing issues. The appellate court has reversed the findings. The appellate court does not appear to have discussed the finding of the learned trial court by reversing the findings recorded by the trial court. No, by allowing the appeal and reversing the decree. At this, counsel for the parties seek adjournment. Post day after tomorrow in the supplementary list.
पास होगा।
पास ओवर ही हो गया और क्या करना है? आपका पास ओवर बताइए, इसमें क्या करना है? देखिए
Item 37.
Page 20, running page 23, appellate for judgment, finding parts, paragraph 22.
आपका पेज नंबर टैली नहीं कर रहा। Appellate court judgment,
का
internal
paragraph
page, internal page,
internal page 9.
हाँ बताइए।
From statement of witnesses of plaintiff and the cross examination it has never been disputed that the suit land was only 14 decimals, which was recorded initially in the name of Lal Chandra Puri, who died leaving behind Ram Bhushan Goswami and Rampal Goswami. Plaintiff is the sole son and legal heir of Ram Bhushan Goswami, and defendant number 2 to 4 are the legal heir of the Rampal Goswami. It has also been not denied by the defendant that 4 decimals land was transferred by Rampal Goswami to mother of defendant number 1, Appealant. So the legal heirs of Ram Bhushan Goswami and Rampal Goswami has half share, each admittedly. And in simple mathematics, out of 14 decimals land, plaintiff shared is 7 decimals and defendant 2 to 4 will have 7 decimals, out of which 4 decimals of land has already been sold by Rampal Goswami, father of defendant number 2 and 3, to mother of defendant number 1, Appealant. So they remains have only 3 decimals of land, and thus they have share of
No share.
no share of 5 decimals. तीन डेसिमल शेयर ये मान रहे हैं, लेकिन 5 डेसिमल मतलब शेयर नहीं. बट द डिफेंडेंट नंबर 2 रविंदर गोस्वामी, son of late Rampal Goswami, has executed sale deed of 5 decimals land without any right title, so it can be no sustainable in the IFLO, and the suit land is remaining the share of plaintiff respondent number 1. So I found the learned trial court has rightly held by the impugned judgment that sale deed executed by defendant number 2 and respondent 2 in favor of defendant 1, Appealant, white sale deed number 6 is void, rightly decided, rightly declared right title interest of the suit land in favor of respondent number 1. ये पूरा 5 डेसिमल जमीन का राइट टाइटल रेस्पोंडेंट प्लेंटिफ के फेवर में, जबकि मान रहे हैं कि 3 डेसिमल जो शेयर है वो डिफेंडर नंबर.
तो ये जो सेल डीड है ये कैसे सेवरेबल होगा? भाई 3 डेसिबल का मान रहे हैं,
3 डेसिमल मान
5 डेसिमल का
हाँ,
सेल
5
डीड
डेसिमल।
एग्जीक्यूट किए,
हाँ 5
तो 3 डेसिमल का कैसे सस्टेन करेंगे? सेल डीड को कैसे ब्रेक किया जाएगा? उसका चौहद्दी कैसे डिसाइड होगा?
नहीं किया जाएगा.
नहीं किया जाएगा.
ठीक है, वो वॉइड उसको डिक्लेयर कर दिए, लेकिन इंटायर 5 डेसिमल का राइट टाइटल इंटरेस्ट जो है वो डिक्लेयर कर दिए प्लेंटिफ के.
हाँ राइट.
तो उसमें 5 डेसिमल में तो 2 ही डेसिमल नाम है.
नहीं 5 + 3 8, ठीक है.
5 प्लस 3
देखिए टोटल था 14 डेसिमल,
14 डेसिमल.
करेक्ट. ओके, दोनों के ऊपर 7 आया, 7 ईच.
हाँ 4 डेसिमल जिसमें हम बेच दिए,
अच्छा 4 डेसिमल आप बेच दिए,
3 डेसिमल हमारा बचा,
3 डेसिमल आपका बचा,
लेकिन हम 5 डेसिमल सेल किए.
आपने सेल कर दिया
5 डेसिमल
5 डेसिमल, ठीक है. तो सेल डीड हो गया सेट असाइड.
सेल डीड सेटिस्फाइड हो गया.
उसके अलावा कहाँ बोला है कि पूरा 5 डेसिमल में रेस्पोंडेंट का राइट टाइटल इंटरेस्ट है? ऐसा तो नहीं बोला है.
अब बोला है
कहाँ बोला है बताइए.
नेक्स्ट पैराग्राफ 23.
20.
So I found that learned trial court has rightly held by the impugned judgment that sale deed executed by defendant number 2 in favor of defendant number 1, right sale deed is void, and rightly declare right title interest of the suit land. Suit land यही 5 डेसिमल के लिए फाइल किया गया है.
कहाँ है सूट लाइन?
सूट लैंड का डिस्क्रिप्शन है पेज
शेड्यूल ए.
पेज 3 अपीलेट कोर्ट जजमेंट, पेज 3 नीचे में. दूसरा कि कोई रीजन्स नहीं दिए हैं आपसे, और as per order 41 rule 31
1 आपका डबल शेयर हो जाएगा. 9 decimal out of 14, you see, renumbered as this area 9 decimal out of 14 decimal. उनको 9 ही decimal मिला out of 14 decimal.
वो तो उनका अपना प्लेडिंग.
हाँ. प्रीवियस पार्टीशन हो
लेकिन
चुका
ये
था.
तो
ये वाला जो पर्टिकुलर शेयर था ये इनके बहुत हिस्सा में पड़ा. ऐसा तो नहीं है ना.
ऐसा नहीं. उनका तो स्पष्ट फाइंडिंग है अपीलेट कोर्ट का इस. जो लैंड सेल हुआ है उसमें अपीलेट कोर्ट का फाइंडिंग है कि 3 डेसिमल्स लैंड डिपेंडेंट नंबर 2 to 4 सोल्ड आउट लैंड.
इसको कल ऑर्डर करें, देख के ऑर्डर करें. ठीक है. SA number 337 of 2018. Heard the learned counsel appearing on behalf of the appellant. They have submitted that suit was decreed ex parte
एक्सपर्ट
and the
अंडर ऑर्डर 8 रूल 10
under order 8 rule 10 in favor of the plaintiff. The defendant was the appellant before the first appellate court. The appeal has been dismissed. The learned counsel for the appellant has submitted that the appellate court has recorded a finding that legal heir of Ram Bhushan Goswami and Ramphal Goswami had half shared each, and therefore the plaintiff had his share as 7 decimal and defendant number 2 to 4 were having share as 7 decimal. He submits that a further finding has been recorded that out of 7 decimal, 4 decimal of land was already sold by Ramphal Goswami, the father of defendant number 2 and 3, to the mother of defendant number 1. And a further finding has been recorded that what remained was only 3 decimal of land. And therefore, the sale deed executed by defendant number 2, son of Ramphal Goswami, to the extent of 5 decimal of land was held to be without any right title. The Learned Counsel has also submitted that the sale deed has been declared to be void and it has been held that the trial court rightly declared right title and interest of the suit property in favor of the plaintiff. The Learned Counsel has submitted that the right title and interest in favor of the plaintiff in the light of the aforesaid facts could have been declared only to the extent of 5 to the extent of
5.
to the extent of 2 decimal. 2 decimal, na? To the extent of 2 decimal, as remaining 3 decimal was still in favor of the defendant. And therefore, a substantial question of law is involved in the present case. Post-mortem. देखते हैं क्वेश्चन ऑफ लॉ फ्रेम करके लेके आए। कुछ एक्सचेंज की भी कहानी है इसमें।
एक्चुअली कहानी है लेकिन वैसा कोई डीड ऑफ एक्सचेंज जो है फाइल नहीं किया गया है।
ठीक।
Item 41, second appeal 431 of 2018.
Wait, Lords, I was praying for not today, Your Worship, because it used to be argued by Mr. Rajesh Kumar. But presently, he has not come to the court because of some personal difficulty.
What is this IS? IS for what? Is there any IA pending?
It has been
Stay.
disposed of probably on substitution. IA was filed, and another is for stay.
It's a judgment of reversal.
Yes, Lord.
Judgment of reversal, my lord.
What was the suit about?
The suit was a partition of 19 decimal of land among 4 brothers and sisters. Earlier there was a suit and a judgment was rendered on compromise. One of the sister took
The
price
suit
of-
was dismissed under Order 7 Rule 11.
Yes, it was filed by the defendant. I am the defendant. I filed it because there was already a suit in which there was a judgment, and the plaintiff of the suit, not of the previous suit of 1995. In 1995 itself, there was a compromise decree, and the plaintiff received 1/4. Now, subsequently, after 14 years, she again filed this present suit. In the previous suit, she was defendant number 3. Here, she is.
There was violation of terms and conditions of compromise. And
Why?
therefore, the second suit was held to be maintainable.
My lord, in fact,
क्या गलती है इसमें?
trial court has held that she has received her share, and the appellate court says signature was not tallying with something. Well, then experts would have been sent for examining it under section 67 of the Evidence Act.
Not necessarily.
Then, my lord, how the court would come to a conclusion that the signature was not genuine?
Court can also compare the signatures.
And the appellate court says their written statement has been filed, whereas from the trial court judgment, my lord, it appears that written statement was not filed, only a petition under Order 7 Rule 11 has been filed.
To try it as a preliminary issue,
Yes,
to reject the plaint,
yes,
that on the Order 7 Rule 11 will be applicable only when on the face of the plaint no cause of action
no
is.
cause of action.
It was not under Order 14 Rule 2.
No. It
So
was
on the,
Order 7
on the
Rule 11.
Order 7 Rule 11.
Because the dispute, the claim of 1/4 share was already decided. If my lord permits me, I may make a prayer that the lower court record may be called. That will clarify so many things. And to hold that the signature do not tally, court cannot compare the two signatures. After 14 years, signatures may a little bit vary.
You see,
The handwriting
Just a
expert
moment.
would come to a
Just a moment.
conclusion.
the
That is
suit was decided by referring
Yes.
to Order 7 Rule 11,
G.
and the suit was dismissed.
As suit was dismissed.
Suit was dismissed
Yes.
as not maintainable,
As no
against which an appeal was filed.
appeal was by the
Where
plaintiff.
is the judgment in the suit?
My lord, it is at page running page 18, my lord, it begins.
Where is the finding?
My lord, it is at page, it starts at page.
You see, it has decided it on the basis of res judicata. Res judicata is a mixed question of fact.
My lord,
It could not, you see, Order 7 Rule 11 applies where if every fact mentioned in the complaint is taken as correct,
correct.
then also the suit is not mentioned.
Yes. Yes.
That is the principle?
Yes.
Yes. So if a person is pleading res judicata, then under such circumstances that is required to be tried.
My lord, I have submitted to Lordship that a petition was filed under Order 7 Rule 11.
Yes.
The learned appellate court says
Yes.
कि res judicata लग गया.
नहीं आपका ट्रायल कोर्ट में भी तो है रेस जुडिकाटा का बात.
ठीक है, लेकिन
Page number 10.
फाइंडिंग देखा जाए.
आप पढ़िए. On the basis of above discussion, in my view, there is principle of res judicata applied under Order 7 Rule 11. कैसे ही लगेगा? उसमें रिटर्न स्टेटमेंट भी नहीं देखना है.
रिटन स्टेटमेंट फाइल ही नहीं होगा.
होगा ही नहीं. तो Order 7 Rule 11 में रेस जुडिकाटा कैसे लगेगा?
रेस judicata वो लिख दिए होंगे, but
नहीं लिख कैसे दिया होंगे? लिखा ही है ये. ऐसे थोड़े होता है.
my lord will
Order
find
7 Rule 11 में this dismissal was
page 25 में
page 10 ट्रायल कोर्ट है.
10 में. हाँ वो तो अच्छा जरा सा उसके पहले का page 8 of the trial court judgment
पढ़ी.
running page 50.
Does the court say आप Order 7 Rule 11 पढ़िए लाइए जरा से please.
अच्छा
When on the face of the plaint no cause of action is there,
yes.
right? उसमें आपको written statement देखने का जरूरत नहीं है.
Rejection of plaint. नाम ही है rejection of plaint.
Yes.
The plaint shall the
Order 7
Rule 11.
रूल 11 पढ़ी.
The plaint shall be rejected in the following cases. तो A, B, C छोड़ दिया जाए.
ABC छोड़ो.
D देखा जाए. Where the suit appears from the statement in the plaint to be barred by any law.
Yes. Appears from the plaint.
हाँ.
प्लेंट से आपको पता चल रहा है कि रूट सूट इज बार्ड बाय रेस जुडिकाटा. बताइए
मतलब
ऐसा कौन सा प्लेंट बनेगा उसमें लिखा रहेगा सूट इज बार्ड बाय रेस जुडिकाटा.
उसमें वो in fact the court means
नहीं व्हाटएवर इट मींस
After
जो
this-
जो
after this-
लिखा है वही पढ़ेंगे. व्हाट
ठीक
द
है.
कोर्ट मेंट वी विल
ठीक
नॉट.
है ना, तो हम फिर हम
कोई एरर नहीं है सर.
नहीं है in the previous suit of
अरे
1995
भाई ये आपका प्ली नहीं सुनेंगे. आपका प्लेंट में खाली देखेंगे इज
नहीं,
इट
नहीं, हम
ऑन द
defendant हैं.
बेसिस ऑफ द प्लेंट
हाँ,
was it barred by res judicata.
on the basis of the plaint no cause of action arose
हाँ सो
because in the previous suit of 1995
because भाई the suit is barred by res judicata कौन बोलेगा? डिफेंडेंट बोलेगा कि प्लेंटिफ बोलेगा?
नहीं नहीं हम बोलेंगे
आप कौन हैं?
आई एम द डिफेंडेंट.
यू आर द डिफेंडेंट. ये तो डिफेंडेंट ना बोलेगा.
हम बोलेंगे आई हैव सेड
नहीं ये तो देखिए डिफेंडेंट का ऑर्डर 7 रूल 11 में बस इतना ही रोल है दैट ही विल कम एंड फाइल अ पिटीशन दैट इज ऑन द फेस ऑफ इट नो कॉज ऑफ एक्शन इज मेड.
नो कॉज ऑफ एक्शन
बस इतना ही.
arises.
इट इज नॉट अ रिटन स्टेटमेंट.
नहीं नहीं
नहीं है. ठीक है. ऑर्डर 7 रूल 11 का पिटीशन फाइल हुआ.
हाँ.
तो ऑन द बेसिस ऑफ द प्लेंट ऑन द फेस ऑफ द प्लेंट इट शुड बी बार्ड बाय सम लॉ.
हाँ
राइट. या मान लीजिए कोई सेल डीड का सेटिंग असाइड फाइल हो गया है
हाँ
ना. 50 साल बाद उसका सेटिंग असाइड के लिए फाइल हो रहा है. नो रीजन गिवन नथिंग
नो
गिवन
रीजन.
नो डेट ऑफ नॉलेज आल्सो नॉट गिवन. ऑर्डर 7 रूल 11 में खत्म हो जाएगा. ठीक है.
In this case, what has
आप
happened?
पढ़िए ट्रायल कोर्ट का जजमेंट. कुछ नहीं है आपका केस में. आपको पता ही है.
नहीं
concede तो नहीं कर
इसमें अभी तो हमको फाइल मिला है.
अभी तो फाइल में तो कल तक तैयार हो जाइए. इतना तो बोल दिया तैयार हो जाइएगा. लिखिए.
इसमें
Counsel for the parties are present.
हमारा प्रेयर है. इसमें मेरे पास प्लेंट नहीं है
कोई चीज का जरूरत नहीं
इसलिए
है.
और वो पिटीशन नहीं है तो इसको हम सिर्फ मंगा लेते
कोई
हैं.
चीज का जरूरत नहीं है इसमें. हम तो ऑर्डर देखेंगे और ऑर्डर करेंगे. कोई चीज का
ठीक है. नहीं हम चूंकि इफ आई एम एड्रेसिंग द ऑनरेबल कोर्ट तो हम वो दो चीज देखना चाहेंगे कि प्लेंट क्या है और मेरा पिटीशन अंडर ऑर्डर 7 क्या है. इसलिए हम कह रहे हैं कि इसको और ये भी टाइम अगर मांग रहे हैं तो एज ए लॉयर का पर्सनल ग्राउंड पर हम कभी अपोज नहीं करते.
वो बात तो ठीक है. उनको तो हम टाइम दिए ही कहा.
नहीं
टाइम तो आप मांग रहे हैं हम आपको
नहीं नहीं वो तो अभी हम मांग रहे
एक बात बताइए. अपीलान का केस डिसमिस करने के लिए रेस्पोंडेंट के सीने की जरूरत कहाँ है?
कोई जरूरत नहीं.
कोई जरूरत नहीं. फिर क्या? कुछ नहीं आपके केस.
इसमें हम नेक्स्ट वीक को रख दिया जाए. मंडे को हम इस वीक में मंगा लें.
Okay. Learned counsel for the parties are present. The suit was dismissed under Order 7 Rule 11 by observing that the title suit number 61 of 2009 was directly barred by res judicata. सूट का नंबर ही था 61 of 2009. The appellate court has reversed the judgment by observing that the learned court had erroneously come to the conclusion that the suit was barred by the principles of res judicata. And held that the suit was maintainable in the present form. The issues were also settled.
Madam,
The issues were also settled.
हमें तो नहीं लगता because the
ऑर्डर में लिखा हुआ है ना सर?
ट्रायल कोर्ट में नहीं हमने देखा.
हाँ देखिए ना.
Para 14.
Civil
14.
settle for determination.
पैराग्राफ तो यहाँ है ही नहीं.
Determination. What point for determination?
हाँ. Now here in para 14, what my learned friend
Just a moment.
wants to read.
The learned counsel for the appellant seeks adjournment. Post this case on Monday at the request of the
मंडे
learned
की जगह पर मंडे 13th है, 15 या किसी और दिन तक.
Post this case on 15th.
हाँ बोलो.
For further hearing. To be taken up at 2:15 as first case. Order 7 Rule 11 वाले judgments लेके आइए. बहुत सारे हैं.
हाँ.
Item 42, second appeal 500 of 2011.
इसमें आपको प्लेट दोनों केस का मंगाना पड़ेगा. कितना चीज लिख दी है प्लेट को.
आपको जो मंगाना है मंगाइए. इसमें भी ऑर्डर 7 रूल 11 है. इसमें भी है.
ये मेरा नहीं. मेरा वो भी.
Item 42.
42.
Yes.
In this paper I break for some times. My
आधा दिन तो सर आप आउट ऑफ स्टेशन.
बस
आज आप आए तो बहस
आज
कर.
फाइल हमको मिला ही नहीं था. मॉर्निंग में फाइल मिला. हमारा कार को एक्सीडेंट हुआ है. कार एक्सीडेंट.
किसका
Not his
एक्सीडेंट?
leg fracture.
आपका?
हाँ हाँ. मुंशी जी का. तो इसीलिए फाइल हमको मिला नहीं था. आज बहुत तकलीफ और 2 महीना से पड़ा हुआ है घर में. आज आया है कोई सूरत से. I could get the file here. I could not
अब फाइल मिल
get
गया.
ready. I could not get ready.
कब करना है ये? कब करेंगे बताइए?
हम 4 weeks टाइम दे दिया जाए।
अब तो फाइल मिल गया ना?
हाँ, अब मिला पढ़ेंगे।
अब 4 weeks का क्या काम?
अच्छा 2 weeks दे दी।
ठीक है। जजमेंट ऑफ रिवर्सल।
हरी बात।
थर्टी फोर का ही तो है, सेक्शन 34 का ही है स्पेसिफिक। That is the only point of determination by the appellate court, that you did not seek your relief in the previous suit.
We shall examine everything also.
देखिए, appearance दे दीजिए। Learned counsel for the appellant seeks adjournment. आपको 2 बार तो हो चुका है। इसमें तो some other counsel was appearing throughout.
किया नहीं।
1000 2000 फाइन आपको लग चुका है। अब कितना फाइन लगा?
ना इस केस में
इसी में लगा नहीं। 1000 रुपए पहले फाइन लगा है, उसके बाद एक दूसरा फाइन लगा है।
एक बार डिसमिस फॉर डिफॉल्ट भी हो गया था, फॉर नॉट, उसको रेस्टोर भी हो गया।
नहीं, डिसमिस फॉर डिफॉल्ट के रेस्टोर होने के बाद 16/10/2024 को फाइन लगा है।
हाँ ठीक है।
उसके बाद उसके पहले 2/9/2024 को फाइन लगा है।
This will be my last prayer also, because I shall be able to contact my client also.
उसके पहले एक बार लास्ट चांस हुआ था 31/7/2024 को। Learned counsel for the senior counsel for the appellant seeks adjournment on ground of his personal difficulty. He submits that the matter be placed on 20th of January 2024, and on that day he has undertaken that he shall not seek any adjournment. Post on 20th. 20 तारीख।
Item 43, second appeal 196 of 2019.
Where is the appellant?
I
There.
This is a defended second appeal against the judgment of examination. The plaintiff filed title suit for declaration of his right title interest and for grant of injunction. The case of the plaintiff is that land of Khata number 73 was recorded in CS record of right in the name of Dilbodh Kumar.
No, what is your point of law then? Substantial question बताइए क्या claim किए? जब बहुत ज़्यादा सब्सटेंशियल क्वेश्चन ऑफ लॉ फ्रेम कर लेते हैं तो हमको लगता है कि कोई सब्सटेंशियल क्वेश्चन ऑफ लॉ इसमें नहीं है। करेक्ट?
Correct. Correct.
इतना Z तक पहुंच गए सब्सटेंशियल क्वेश्चन।
Correct.
Z नहीं M। कितना गिनिए कितना हुआ?
हमारा सी है whether the findings of the Relevant Court of Appeal was deceptive due to misconstruing the exhibit to that is auction sale certificate while deciding the issue of title against the defendant.
बताइए इसमें क्या मिसकंस्ट्रक्शन है?
The land of Khata number 73 was recorded in the name of Dilbodh Kumar in CS record of right. Thereafter, the recorded tenant lordship could not cultivate the land and did not pay the rent. Thereafter, a rent suit was filed and said land was auctioned in favor of the then landlord and in the name of great grandfather of the plaintiff. After thereafter, Lord, a amicable partition took place between the landlord and the great grandfather of the plaintiff, and 4 decimal of land was allotted to the great grandfather of the plaintiff. After vesting, Lord, the then landlord filed return showing the position of the plaintiff. The findings of the learned trial court is that no record was filed by the defendant with respect to his title loss.
नो रिकॉर्ड वही तो गया, क्या ही बचा
इसी तो
लिखिए
कुछ है नहीं. हमारा कहना है कि कुछ ऑप्शन से हुआ ही नहीं है.
Second appeal number 196 of 2019. Heard the learned counsel appearing on behalf of the appellant. The learned counsel for the appellant has submitted that the appellant was the defendant before the trial court. The suit was decreed in favor of the plaintiff and the appeal has been dismissed. He submits that though there are concurrent findings recorded by both the courts, but the findings of the learned appellate court is vitiated due to misconstruing Exhibit 2, that is auction sale certificate, while deciding the issue of title against the defendants. The learned counsel has submitted that in fact there has been no auction of the property in favor of the ancestor of the plaintiff
And the then landlord.
who were the then landlord. After hearing the learned counsel appearing on behalf of the appellant, this court finds that the plaint was filed, the title suit was filed being title suit number 52 of 1998, seeking declaration of right, title and possession of the plaintiff over the suit property and also permanent injunction against the defendant not to interfere with the right, title and possession of the plaintiffs.
Issue number is 8 and 9 important.
Just a moment. The learned trial court framed the following issues for consideration. कहाँ है?
Para 7 of the learned trial court judgment.
तो हिंदी में है ना?
हिंदी में.
इसमें भी तो किया हुआ
इंग्लिश
है.
में भी है.
हाँ, पैरा 5.
Para
पैरा
5.
5.
जी.
ठीक है ना?
जी.
और the appellate court judgment से लेंगे. The main issue for consideration before the learned trial court was primarily issue number 8 and 9.
जी. Para 10 lots of mechanism.
Trial court का पैरा नंबर?
जी. Para 10.
पैरा 10. The aforesaid issue was decided by paragraph 10 of the trial court judgment. And upon consideration of the materials on record and the evidences produced by the parties, the learned trial court recorded a finding in para number 13 that the ancestors of the plaintiff got the property through sale in rent suit and they have been paying rent in connection with the property to the state. The learned trial court considered the materials on record and held that the plaintiff has been able to prove right title interest and also possession with regard to the suit property. The learned trial court also referred to the rent suit number 399/1917 and also in connection with the property involved in the present case. During the course of hearing, the learned counsel for the appellant has not been able to satisfy this court as to how the auction sale certificate exhibit 2 is said to have been misconstrued. The appellate court also considered the materials on record and decided the aforesaid issue relating and framed the following point for determination quotation whether issue number 8 and 9 were properly decided by the learned court. The learned appellate court considered the materials on record, discussed all the material evidences placed before the court, and ultimately dismissed the appeal. And confirmed the judgment passed by the learned trial. In view of the upon going through the both the judgments, this court finds that no question of law, much less any substantial question of law, arise for consideration by this court in this second appeal. which is hereby dismissed.
Right.
कुछ इसमें हम ऐड करेंगे
जी।
पैराग्राफ डाल देंगे।
कुछ है नहीं तो उसमें
फिर कोई बात नहीं।
Item 45, second appeal 130 of 2020.
Yes, appellant.
Your Lordship, I pray for time.
It's rejected. Pray for time is rejected. ₹1,000 तो आप एक बार दे चुके हैं। इस बार टाइम मांगिएगा तो ₹10,000 देना पड़ेगा।
Your Lordship, my senior is out of station.
कोई बात नहीं, आपको बोलिए, आप पढ़िए।
Your Lordship, this is a judgment of reversal which has been passed by the
बताइए।
which has been passed by the learned district and
It
business.
is a case for specific performance of contract.
Yes, ma'am. Specific purpose.
Suit was decreed.
This was preferred as a title suit for which
It was decreed.
yes,
The suit was for specific performance
for
of
specific
contract.
purpose.
Okay, it was decreed.
This word it was decreed
अब बताइए।
for title suit.
Decreed for title suit means title suit. The plaint was for specific performance of contract. Title suit बोलिए चाहे
For
कोई
the
भी बोलिए. How does
sale
that?
deed of
That's right.
yes.
Yes. अपील में क्या हुआ?
Your Lordship, the defendant in the plaint, Your Lordship, he has pleaded that the money for what he has given for 53,000 rupees, that was not for the sale deed. He plead that it was given as a money which was taken as a loan, but it is clear in the judgment.
It must have been
passed-
mentioned in the agreement for sale.
Yes, Your Lordship, it was mentioned in the judgment also, Your Lordship. In the judgment passed by this district judge of Dhanbad, it is clear that
You see, आपका written statement देखिए. He accepted the fact that he had received an amount of ₹45,000 as loan for social work, and he had put signature on 2 stamped papers and 2 blank papers, and he had put his signature upon the papers. And he returned the said amount. He has taken loan from the plaintiff's father, which was returned through check number such and such. Such and such. Plaintiff was not examined as a witness.
Your Lordship, I am not well versed about facts of this case.
क्या बोलना है बताइए?
Lordship, the case is simple.
सिंपल। तो फिर बहस करिए, ठीक क्या है?
I'm not aware. Your Lordship, at first the defendant of the case came to the plaintiff for the sale of land deed, and when it was executed at around rupees 53,622, then he started pleading that the
The
money.
entire consideration amount was paid,
Yes, your Lordship. The entire consideration amount was
but
paid.
still the deed was not executed.
The deed was executed, your Lordship.
The sale deed.
Sale deed was.
Nothing was remaining to be paid.
No, your Lordship. Nothing was remaining. And total consideration money has been paid to the defendant before, dated 25/4/2005 as per.
What was the case of the defendant before the court?
The case of the defendant was, your Lordship, the case of the defendant was that the present suit is grossly undervalued at.
Para 3 पढ़िए trial court का judgment. What was your case?
Case of the original plaintiff before the lower.
Defendant. Para number 3 of the trial court judgment.
Here it is clarified that the plaintiff.
Defendant appeared and filed his WS.
Here in the defendant before the lower court is appellant.
अपना केस पढ़ेंगे ना? The suit was decreed, right? आप defendant का केस पढ़िए.
Defendant appeared and filed his written statement by taking therein regular defense that the plaintiff has got no cause of action for the present suit, and the present suit is not legally maintainable. The suit is barred under the provision of Specific Relief Act and limitation. The suit is barred by the law of estoppel, waiver, and acquiescence. The present suit is grossly undervalued as the market value of the suit land is more than rupees 53,620. No amount has been received by the defendant for any agreement. He accepted the fact that he had received the amount of rupees 45,000 as a loan for some social work, and he had put his signature on 2 stamp papers and 2 blank papers, and he put his signature upon the papers. He returned.
So his signature is not disputed, correct? Yes, his signature is not disputed. That was his case. He had put his signature on blank papers. आगे पढ़िए.
Put his signatures upon the papers. He returned the said amount. He has taken loan from plaintiff's father, which he was returned through a check number such and such of rupees 45,000 on 24/10/2005, and interest rupees 8,622 paid by him in cash. There was no agreement prepared between the parties. The plaintiff has practiced fraud and has not came in court with clean hands.
Basically, your case was that the documents which were signed has been misused.
Yes.
What is the finding of the learned trial court? So, appellate court has reversed the decree, no?
Yes.
Let us see the finding of the learned appellate court on this.
Lordship, first finding whether the contract for sale dated 25/4/2005 with respect to scheduled land in favor of plaintiff is still subsisting. Second,
Point number 20, para number 20, whether the plaintiff respondent was ready and willing to perform. बहुत सारा डिटर्मिनेशन का पॉइंट कंसिडर किया. Point for determination.
Determination points number 3rd and 4th.
The plaintiff does not depose, right?
Yes, Your Lordship.
The power of attorney holder deposed in place of the plaintiff.
Yes.
Permissible. What has been held? Is it permissible? So he has said that the power of attorney holder did not have any personal knowledge about the transaction, and therefore he could not have deposed. Correct. So what is wrong with this man?
Your Lordship, at first the sale deed was executed. The whole amount was given in through cash, which.
No, we are not on that. We are just point wise taking. Point of determination number 1. You tell us what is wrong with this finding.
Whether holder of power of attorney can depose for the principal.
Internal page 10 में आइए appellate court judgment. Just above para number 17.
Yes.
Para number 18.
In appellate court judgment.
Yes. In my mind, the power of attorney holder does not have any personal knowledge. Padi.
At the time of hearing the learned counsel.
No, I am not on that. Para number, internal page 10 of the appellate court's judgment. Am I loud and clear?
Yes.
Come to internal page 10 of the appellate court's judgment. Just the last sub-para of para number 17. In my mind,
the power of attorney holder does not have personal knowledge of the alleged matter of the plaintiff, and therefore he can neither depose on his personal knowledge nor he can be cross-examined on those facts, which are to the personal knowledge of the principal. Thus, it is crystal clear that the power of attorney holder have no power to depose in this matter on behalf of the plaintiff. Yes, Your Lordship.
उसके पहले वाले पेज में आइए. I further find that on the basis of alleged power of attorney, plaintiff's father came to the court and stepped into the witness box and gave his evidence, right?
Yes.
So power of attorney का तो कहानी खत्म हो गई. The plaintiff was not examined. तो क्या ही बचा? Just tell us what is left.
If he has no power.
Power of attorney cannot depose on behalf of anybody.
Anybody. Yes.
Right? Power of attorney is only to file the case. He cannot depose. ये देखिए issue number 2 जो है, in the present case I find that the plaintiff Ashok Bhushan did not come forward before the court as a plaintiff witness to prove the fact that he has to put his signature on the agreement.
Yes, Your Lordship.
ठीक है?
If he
And
has
on comparison of the signature with open eyes, it was found that it did not match. Correct?
Yes.
तो फिर क्या बचा? Plaintiff could not prove his case. He did not come as a witness. He did not prove his case. His power of attorney was pursuing the matter. क्या ही गलत है बताइए? Hence, it is important that defendant witness came forward to say that there is no agreement of sale. Then determination of point number 3 and 4. Suit, you see, the suit was not instituted by the power of attorney holder. It was instituted by the plaintiff himself.
Yes.
Right?
Yes.
I find that the plaintiff filed wakalatnama with his signature and he appointed somebody as others as advocate. plaintiff did not come forward to support his case. पहला नोटिस आप भेजे हैं 24/5/2006 को, सेकेंड नोटिस 25/6/2006 को. सेकेंड नोटिस का कोई प्रूफ नहीं दिया. सिग्नेचर भी डिफर कर रहे हैं.
Lordship, he had personal knowledge about his agreement. That's why he has deposed the same.
No, there are many other things, no? Readiness and willingness and so many aspects in case of specific performance of contract. So for that, plaintiff was required to be examined. Power of attorney की तरफ से कैसे किसी plaintiff का evidence हो जाए? It is not a case that plaintiff was not called upon to depose, right? He was called upon to depose, but instead he filed the suit himself, but he sent power of attorney for examination and cross-examination. He disappeared. He has virtually disowned the suit. Power of attorney को भेज दिया, उनका होगा. Power of attorney को फांसी पे भी चढ़ाने का कोई इंतजाम होना चाहिए. नहीं होगा क्या? नहीं होगा ना. Specific performance of contract में power of attorney से नहीं चलेगा केस. There are many things which are required to be examined, cross-examined. There is no illegality in the order. Judgment of reversal होने से कोई question of law होता है ऐसा तो नहीं है. कोई judgment है ऐसे? Reversal होने से question of law हो जाता है. नहीं है ना? लिखिए.
But your Lordship.
अब क्या? आपके सीनियर आपके बगल में बैठे तो हैं?
No, your Lordship. The signature just.
कौन सीनियर?
Just one.
तो कल है कोर्ट में नहीं आ रही हैं? She is not attending any court.
She is not in the town tomorrow.
कल.
After this week, she will be present. And she is not in the town. That's all.
एक हफ्ता में एक दिन भी कोर्ट में नहीं दिखने चाहिए. हमको पता लग जाता है.
Yes, your Lordship.
Sure?
Sure.
Yes, madam. She is not there. Tomorrow. Learned counsel for the appellant is present. He has placed both the judgments of both the courts. The matter arises out of specific performance of contract which was decreed by the learned trial court but reversed by the learned appellate court. The plaintiff who had filed the plaint did not appear for his examination and cross-examination. Rather, after filing the plaint, his power of attorney was appearing before the court. The learned appellate court has taken serious objection to this and has reversed the decree. At this, counsel for the appellant submits that the matter be posted tomorrow and his senior will assist this.
Day after tomorrow.
अभी तो वो मैडम बोली है tomorrow I will believe her. उनको विश्वास ज़्यादा करें ना. मिसेस मजूमदार का केस है तो उनको ज़्यादा विश्वास करेंगे. Correct? Post tomorrow.
Item 46, second appeal 132 of 2020.
This is against judgment of concurrence. I was the defendant in the original suit.
suit was filed for declaration of right title interest as well as for cancellation of gift deed through which I am claiming my title. Lordship, the case of the plaintiff is that they are the legal heirs of the recorded tenant. My case is that the ancestors of the plaintiff executed an unregistered Rajinama in the year 1966 through which my father came in possession. Thereafter, my father transferred the said land through a registered deed of gift in my favor. So I am claiming my title on the basis of possession.
Title of your father, any issue on adverse possession free?
Yes, ma'am. So, if I may just place the facts briefly with us. So, if the trial court has come to a conclusion that I was in possession of the land for more than 12 years. So, I came in possession way back in the year 1966. The suit has been filed in 2010. It is an admitted fact that I was in possession. There was a proceeding under section 87 of the Chota Nagpur Tenancy Act as well that was decided in my favor. Thereafter, I have been paying rent to the state as well. And even the trial court has come to a finding that I have been in possession of the land for more than 12 years. Despite that, the trial court and as well as the appellate court has came to a finding that the plaintiff is entitled for recovery of possession. The illegality, my lords, is that?
On what ground?
Yes. So the law has changed, my lords, in 2019 after the judgment of Ravindra Kaur Grewal, that even on the basis of adverse possession, I can claim title. So firstly, if I show that it is an admitted fact that I am in possession.
We'll take it. Then further, what is the ground? You were the plaintiff?
I was the defendant, my lords.
You were the defendant?
Yes.
So as a defendant, you could have taken a plea of adverse possession.
So I have taken the plea and it has been decided also that I was in possession of the land for more
then
than
why the suit has been decreed?
Yes, both the courts have decreed the suit on different grounds. The trial court has just decreed the suit that I have been unable to prove my title because title cannot flow from an unregistered document. But I am not claiming my title through
Forget about unregistered.
Yes, I am claiming my title through possession. It has not been decided by the
So
trial.
it was an alternative plea, must be.
No, that is what the appellate court has held. That it was an alternative plea of adverse possession. So therefore, inconsistent plea of adverse possession is not maintained.
It is not inconsistent, is it?
That is what the appellate court has held. But in my case, it is not an inconsistent plea. That is what I am submitting. I am clearly submitting that I came in possession of the land through that. I am not claiming my title through that Rajinama. I am saying that I came in possession of the land through that Rajinama. I am claiming my title through that possession. If I was saying that I am claiming my title through Rajinama as well, and I have perfected my title through adverse possession, then there could have been an issue of inconsistency. But I am not saying that. I am just saying that I came in possession through the Rajinama, and thereafter I have perfected my title through adverse possession. So, if your lordship, if I may invite the attention of this court to running page number 25 for a moment.
What is the point of law you have framed?
Yes, that is. Point number D and G. G is important minus because both the courts have come to a finding that I was in possession of the land for more than 12 years. And despite there being an admitted fact, the suit has been decreed.
The time is over. Will you come tomorrow? Essay number 132 of 2020, the arguments of the appellant to be made conclusive.
Let us pass on the judgment.
Post this case for further argument. Give me one judgment. Whatever judgments you want to pass on, please.